Welcome to Planning for Protection.
Welcome to Planning for Protection with attorney Jeff Ryder. Jeff is an elder law and estate planning attorney serving families across Carroll County and the surrounding Indiana communities. I'm Leanne Lyon, and today we are talking about wills, trusts, and how each one protects your family in different ways. Hello, Jeff.
Hello, Leanne.
Jeff, families often think a will and a trust do the same thing. Could you start by explaining how they differ in Indiana?
Well, in a way, they are similar in that they both make clear a person's wishes when they pass away. And that is, in and of itself, a very valuable thing because if you don't make it clear, Indiana has a will for you through the intestacy statute. And that may or may not reflect your wishes, especially if you have a second marriage and or children and stepchildren or children and maybe a deceased child. And so it's important to plan whether you do it through a will or a trust.
So, how are they different from each other in
Well,
Indiana?
the biggest difference is if you have a will only, that will have to go through probate in Indiana.
Mhm.
And that is a somewhat scary word for many people. Uh, but probate basically just means that there is some court involvement with the process after your death. And that Indiana has unsupervised administration as an option, which allows the court involvement to be fairly minimal. And there are some protections baked into the court process, such as a notice that gets published to creditors and a deadline by which creditors must present their claims. So the probate process has its value and its uses, and it's not nearly as expensive or as time consuming as many people fear. For
Mhm.
instance, in Indiana, the time for filing a will contest is 3 months. The claim, the period to file a claim is 3 months if you publish the notice, and so it doesn't take as long, and it doesn't take as much money to settle an estate as people generally think. But if you have a trust, it's almost certain that you will not have to go through probate, and it is almost certainly true that it will be less costly. So a trust can reduce costs and speed up the settlement process.
So, when somebody wants to make things easier for their children, what situations lead you to recommend a trust instead of relying on a will?
Okay, well, that's a very good question, Leanne. As one big thing that comes to mind is if the people own assets in a different state other than
Mhm.
Indiana, because if they own assets in a different state, depending on how they're titled, it may be necessary to open an estate in both states, which does, of course, increase your cost and to some degree your time. So if you own assets in another state, it becomes especially important to have a trust, which could be the owner of those assets in the other state. Another reason to consider having a trust is if you just have a lot of assets with a lot of value, because to a degree, there's a certain amount of work, whether you have a small estate with very few assets or you have a big estate. You've got to still open the estate, you've got to file the petition, you've got to publish the notice, you've got to do the inventory, you've got to do the accounting, you've got to do the distribution of assets, pay the claims, if any, and so all that, there's a certain cost associated with all that, whether you have a small estate or a big estate. So the bigger your estate, the more likely you would be to want to have a trust to save some of the money that would otherwise be payable. Another big reason to have a trust is if you are concerned about trying to protect your assets. An irrevocable trust has a big advantage of being able to protect assets that a revocable trust in Indiana now does not have. It used to be that revocable trust in Indiana did offer protection, but they no longer do that. So that's why we have shifted to doing a lot more irrevocable trusts.
Interesting. Well, we've thrown around words like estate and assets, but I know some families are really focused on protecting one in particular, and that's their home. How does a trust handle real estate differently than a will under Indiana law?
Well, avoiding probate, that's the biggest single benefit of having a trust.
Hmm.
And the other thing is sometimes people have a family member with some sort of special need, perhaps
Mm,
a disability of some sort, where they're on a public benefit program themselves, perhaps addiction of some sort, where an asset could be used poorly if they receive it outright, and you want to put it into a trust to help protect it for their benefit. So, all those things can be accomplished through the use of a trust that would be more difficult through a will. So that would
okay.
that would be why someone would want to consider putting their house into a trust.
Got it. Well, I think wills are often seen as a set it and forget it type of a document. But what kind of problems does that create when assets or family situations change over time?
Well, that's a good question, and I would say if you have a will, I think you should consider at least updating it every 5 years or maybe every 10 years. But anytime a situation or circumstance changes, say maybe one of your children passes away and for whatever reason you're not close to that child's children, your grandchildren, and you decide you don't want to leave money to them. You want to leave it to your surviving children. And so you would have to make steps to update your will to do that, because oftentimes our will say to our children, and then if they predecease, to their descendants per stirpes, which would be their descendants based on whether, well, it's by the writs. It's a Latin phrase that means that the property transfers by the writs. So if your child has three children, his or her share would get split three ways amongst his descendants. If one of those children had died and had children, that person's share would get split amongst his or her descendants. So if you don't want that result, then you would need to update your estate plan.
Got it. Let's talk about privacy now. What should families know about which documents become public and which ones stay private after somebody passes away?
Good question. Well, in Indiana, if you have a will, that will would get probated in the county in which you died a resident. And that is a public record. So
Mm,
any snoopy, nosy person that wanted to could go up and look at your will and see, oh, that's whatever arrangement you might have that would be unusual or atypical would definitely be a public record now that could be reviewed by any nosy person. In Indiana, the form asks you to list the value of your assets. Now, in our practice, we do not list the value of those assets. We say unknown because we don't know what they are typically as of the time we're doing it, which is shortly after date of death, which
right.
also helps protect and preserve the privacy of the family, because that way people don't see a list of every stock or bond or every piece of real estate you own. It's set just as unknown. So there is still some privacy, but the will itself is a public record that has to be presented. The trust, not so. You can have that trust presented for recording, but most people don't, and there's no reason to do that. So it can be a
Mhm.
private document that's basically known to your family members and your executors and trustees.
Is there a story or example you can think of where choosing a will instead of a trust or vice versa made a noticeable difference for a family that is settling an estate?
One comes to mind. We had a family friend who had lived in Indiana all her life, and eventually moved to another state to be closer to her only surviving child. and uh, they retained ownership of some assets in Indiana. And in beautiful hindsight, it would have been better, I think, if she had created a trust in her state where she had moved to, because uh, it complicated things a little bit to try to
Mhm.
administer the assets in Indiana because of the way she had set things up in the state she had moved to. So yes, it definitely um, can be can streamline things and make them simpler and cheaper if you have a trust.
Excellent. Well, some families wonder whether a trust will really help them with the long term care planning or Medicaid concerns. So, in what situations can a trust support those goals?
Well, as I think I had touched upon, in the past, a revocable living trust helped protect assets from estate recovery by Medicaid. Anymore, that is not true because they've changed the rules and the law. And so now an irrevocable asset protection trust is the trust that can and does protect assets from the possibility of estate recovery. And depending on, they can also make them non-countable assets for a Medicaid application purpose. So it protects both during your lifetime as well as after your death.
Well, so this is just a decision people should just roll the dice and make a decision on their own, right? When they're trying to decide between the two?
No, I don't think that's a good idea. I think
No?
they should talk to an elder law attorney. Of course, I would volunteer to be that attorney, but at least talk to somebody who is going to be able to give you all the information. And every state is different and unique. And I only practice in Indiana, and I only know the rules in Indiana. And I think you should talk to an attorney in your state who can give you accurate and knowledgeable advice. And the other thing I would say, occasionally I will talk to an attorney who had, and I'm just going to say, it appears that they dabble in elder law and the estate planning aspects of elder law. And for instance, I talked to an attorney in the last 3 months where he was citing rules that had been changed probably 25 years ago,
No.
and he was very positive he was right, and I had to say, no, I'm sorry to let you know, but those rules have changed over 20 years ago. So you don't talk to somebody who dabbles in it. Talk to somebody who is very actively practicing it, because there's just so much to know, and it does change, and it's a challenging job to keep up with the changes, but I do my very best to do that, and I attend every educational opportunity I can to be as on the cutting edge as possible. And I think I am. I try very hard. In elder law and in Medicaid eligibility rules, there are very bright lines. And I liken it to a football field. We're trying to make yards to get down to the goal line and score a touchdown. And the touchdown is Medicaid eligibility in this situation. And I believe that you can go right to the line and maybe be on the line. I don't know football rules that well, but there's rules about the line. And we try to get as close to the line as we can without going over the line.
Mm.
And we try to exhaust every available opportunity to give the best financial outcome for the family that we can. And so I personally take pride in our attempts to do that. And I think we succeed with that attempt very often.
And that is why they say specific is terrific. Well, as we wrap up here, what factors matter most when choosing the right approach for a family's needs?
That's a very good question. What I do when I sit down with the family, I try to get enough information to where I think I can give them the assistance that they need and deserve. And so that generally involves talking about their family situation, their children's spouses, their grandchildren, if it's a second marriage, the the children that would have, if it's a second marriage, I think it's especially important to know the dynamics and the plans and be able to try to plan in such a way that it accomplishes the goals of the person. The other big factor to focus on is, what do they have an old trust? If they have a trust that predates the change in the law in Indiana, then it ain't broke. We won't fix it. We'll just utilize that old trust. On the other hand, if it is not an old trust, then it's not possible to do that. And then we would talk about their assets. What do they have and what are they most passionate about? Some people are like, the farmland is the thing. This has been in the family 3 or 4 generations. We do not want to lose the farmland. The money is a different thing. It's not as important to protect the money as it is to protect the farmland. Other people, it could be the stocks or the bonds or whatever. So whatever it is that's important to people, we try to focus on achieving their goals to protect those assets and to give the best option that has the best situation that has the most options for the family and the best overall result.
Perfect. That sounds amazing. Well, that's it for today's episode of Planning for Protection. If you'd like to learn more about attorney Jeff Ryder and his work at Jeffrey C. Ryder, Attorney at Law, LLC, visit jryderlaw.com. And thanks for listening. And remember to like, subscribe to the show, and leave a review if you found this episode helpful. Thank you, Jeff.
Thank you, Leanne. Have a great day.
You too.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.